My name is Dapi, so I'm the legal advisor within Sen and Senelec, dealing with issues related to, including among other things, intellectual property rights, including patents and copyrights. So today we will try basically to go through the relevant issues that touch upon our activities within Sen and Senelec and general standardization with regard to intellectual property rights. And the content will refer basically to understand what are the intellectual property rights, how they reflect in the standardization domain. Specifically, we will go through the relevant aspects related to the copyrights of the standards and how they relate within our activities and the deliverables, the publications. Then we will examine in more detail the issues of the patents in standards, standard essential patents, what implications are there, and how they're being addressed through our relevant Senelec policies and the system and the practices. Then we will understand a bit how patents relate to the different interests that are coming together in the standardization world, meaning interest between patent holders and standard users, and some final considerations for us. The aim today of this webinar is to give you an overview of the relevant IPR issues to help you understand better how it works, and of course to give you the opportunity to raise some questions, some clarifications that you would like to bring to the discussion today. So what I would suggest is if you have any questions, please post them on the relevant panel. After the part on the copyrights, we will have the opportunity to raise some of these questions, specifically on copyrights, and then we'll go on the patents issue. Then again, we will have the opportunity to raise questions on patents. And if then you have some further questions, then we will have further discussion on this. And as I mentioned, the aim is to help particularly those who are involved in the relevant technical work, for example, experts, technical body officers, our members, but also other organizations and colleagues who are interested in the domain to understand a bit better how it works and to be able to be prepared to address the relevant issues whenever they arise in order to ensure that there is clarity and consistency in the relevant work. So let's go then first understand definitions of what are IPR. There's sometimes confusion and not sufficient clarity. The reason for that being is that different countries, they have different legal frameworks for that. The US, for example, Europe, China, Japan, Korea, or other countries. However, there are some common frameworks which are which apply across the board in various jurisdictions. So in order to understand the IPR, we have to understand that intellectual property rights refers to an intangible asset, something which has been created through the mind and is to this intellectual creation, the law grants for a specific time, so on a temporary basis, some rights. So the law grants the rights to the creator, to the owner of the relevant intellectual property rights, because the law would like to reward such like author and the IPR owner for the fact that she or he has created such intangible assets for the benefit of society. Yeah? So there is a trade-off there, whereby the law and society grant some protection to the IPR owner for the benefit, for the fact that this IPR owner will disclose this information to the public and allow the use under some conditions to the public. So usually when we refer to IPR, this includes copyrights, trademarks, patents, industrial designs, domain names, and various other elements. Normally, trade secrets are also included in that, but since by definition they're expected to be secret, it's not something that we relate as much here in the standard development process. So a practical example. Let's say we take this laundry machine. It's a Bosch laundry machine. The choice was by chance, by the way. So Don't be alerted by that. Some various aspects we have here. We have the registered company name. So it's Robert Bosch GmbH. The commercial name is Bosch. The name boschindustrial.com. So already we have some IPR here. So we have the trademark, we have the domain name from that regard. So some other trademarks that we have, which Bosch has registered as the ones you see in the right. So you have graphical symbols and letters, but also the letters themselves as they are being represented. This normally are registered in various trademark offices around the world. Now we have the design itself, which is the body of the laundry machine, which can also be protected. Then we have the patent, which refers to the engine and the drum itself. And we have copyrights, which refers to the user manual of the laundry machine itself. And of course, around 15 European standards which relate to this laundry machine. So you see how standards in this case relate already with various IPR elements within this specific product. Now, some key elements which arise, key aspects which arise in the standardization world with regard to IPR refer to the copyright of the standards and the patents which may arise with relation to the standards. So they relate to the content of the standard as well, but usually they're owned by other organizations. So first we will examine, as mentioned earlier, the aspects related to the copyrights of the standard. So the standard as a publication, as a product itself. Patents, by the way, are reflected in the CEN/CENELEC Guide 8. So in the CEN/CENELEC we have various guides to reflect more specifically on policies in the targeted domains. So the CEN/CENELEC policy on patents is reflected on Guide 8. The CEN/CENELEC policy on copyrights is reflected on the CEN/CENELEC Guide 10. It is the policy on dissemination, sales, and copyright of the CEN/CENELEC publication. So we will touch upon various issues across these guides. However, if you would like to receive more information, please go on these guides, have a look on them because they're quite detailed and really describe how the system works with regard to various aspects and the approach and the policy of the organizations with various areas which are touched upon this. So as mentioned then, two main types of intellectual property. It's the Guide 10, which is for the policy on dissemination and sales, and Guide 8 for the patent policy, and specifically for standardization patents. And of course, these are available on the CEN/CENELEC website. So if you go on the CEN/CENELEC website, you will find both these guides, which are publicly available for your information. Now, let's go first on the IPR of the standards related to the copyright. So we will first try to explain, to understand how the copyright of the standards is established, how the copyright claim is established, how this is transferred to CEN/CENELEC and their members, and how CEN/CENELEC ensure the protection and the enforcement of these copyrights. So three simple concepts to understand about the copyrights. The first one, what is a copyright? So copyright is intellectual property. So it's something intangible asset, which is an original work created by its author and by law is granted some exclusive temporary rights, which is usually the life of the author plus 50 or 70 years. And then, as I mentioned, it needs to have some original work in itself. So could be textual, could be graphical, could be plastic, musical, dramatic, audio, visual. So there has to be a creation by the mind which needs to be original in nature. So something which is includes some creative work by itself. The purpose by granting copyright under the law is to place the author in a position which he or she can decide when and where to exploit the original work that this person has created. So the law grants the author the exploitation rights to this creation, to this original work. Now, a question which arises very often: are the SEN standards or other technical documents, publications protected by copyrights? And then the answer is yes. And this is what we will try to establish through this discussion right now. Particularly for the case of standards, we have to understand the nature of the standard development work. So practically speaking, what we have is we have a technical group where the various experts are gathering together to discuss and develop the standard development, the standard content itself. So what this means is that various experts come together, they bring in their creative work, and they try through this process to establish the content of the standard. Sometimes it is possible to distinguish what an expert has contributed. Sometimes it's not possible because they have all contributed together. There is reformulation, there is discussion, and then the content of the standard is established under a consensus basis. In other occasions, maybe it's possible that various organizations would like to contribute the content of their publications into the standard itself. That's possible as well, based on agreements that these organizations have with SEN and SENLEC, and we'll touch a bit later on that. The main issue, however, is that normally the experts contribute state-of-the-art content in the standards, and through this collaborative process, there is a collective work which results, which is the standard itself. So we expect in that case that any expert in the technical committee or working group has the copyright of the written identifiable contribution that he or she makes. However, we have to bear attention that at the beginning of the meetings, the experts complete a statement which is called the exploitation of rights, the assignment of rights statement. So whenever the experts join the meeting because they want to attend to that, they are requested to complete and sign this assignment of exploitation rights statement. What this means is that in those cases where it could be identifiable that the expert has contributed something to the standard content, by this statement, the experts assign the exploitation rights to their original work to SEN and SENLEC. At the same time, though, the experts maintain and keep their moral rights to their contributions. And again, we have to emphasize that this is in the cases where, first of all the experts sign this in any case, just to have a consistency in the system. However, particularly this refers to the cases where there is a contribution which could be identified as origin to a specific expert. In most cases, this is not practically possible because, as I mentioned, there is quite some discussion, creative work, and consensus-based standard development process. However, even if that arises, so I see a question here, what are the moral rights? In that case, the experts maintain the moral rights. So moral rights means that the expert can associate their name with the specific contribution and creative work. For example, imagine if someone creates a painting, then this painter has the ability to sell the painting itself. However, the painter maintains the possibility to associate her or his name with a specific painting as well. Also, what this means is that under this statement which the experts sign, they have the ability to use this contribution for their own purposes. For example, if it is an expert which is a professor at the university and would like to make a presentation at the university which relates to the specific identifiable content. So this expert has the ability to use this for this presentation. Or if the expert would like to write a publication, a book, in the context of a research that the expert is doing, they are also able to use this for that purpose. However, the only restriction is that this should not be in a way which would harm the standard itself. So it should not be something which would inhibit the publication or the exploitation of the standard by the SEN and SENLEC members. So there is, of course, some flexibility there, exactly because there is a desire to have the best possible knowledge in the contribution of the technical committees. That's why this exploitation rights statement allows the experts to continue using their identifiable contributions for their own purposes, as far as this does not harm the content or the publication of the standard itself. So as I mentioned earlier, the Standardization policies on copyrights is Guide 10. It's our Bible with regard to the commercial use and the copyrights of the publications. And something which needs to be clarified as well is that Standardization themselves do not sell standards. They essentially create and publish the standards. However, it is the CEN and CENELEC members, so the national standardization bodies, NSBs, for CEN, and the national committees, NCs, for CENELEC, which are selling the standards. And for that purpose, CEN and CENELEC have transferred in turn the exploitation rights of the entire publications to their members, so that they are able to sell the standards in their national countries. Sell it is exactly because the CEN and CENELEC members are required to adopt the European standards in the national context. There is a national implementation in the various languages. So normally the content of the standard is published in the 3 official languages, which is the English, French, and German. Then the members have the right either to adopt in one of these languages, or they can translate into their national languages. So for that purpose, CEN and CENELEC transfer all the exploitation rights to their members so that they are able to adopt, implement, and distribute the standards in their countries. Now, in that context, we have a specific group within CEN and CENELEC. It is called the CEN-CENELEC Joint Commercial Advisory Group, JCAG. This group supervises the implementation of the Guide 10, addresses specific issues. So whenever there is an issue which is not currently addressed in the Guide 10, or which requires further clarification, in those cases, these issues are addressed to JCAG, which provides recommendations to the CEN and CENELEC boards in order to take sufficient actions whenever that is deemed necessary. Yeah? So there is an ability, of course, in the system to have some flexibility to allow specific issues to be addressed on ad hoc basis, or to interpret the rules as this is deemed necessary, considering that the standardization world is evolving, so there are always new issues arising in that context. I will go through the presentation, and then maybe we can discuss a bit further about the questions that you have raised. Now, some questions which arise sometimes reflect to the content of the standard itself. So some people ask, but are there copyrights for the terms and definitions, for the graphs, tables, pictures, labels, and stickers? And the answer to that is yes, there is copyright protection granted for all these elements. So graphs, tables, terms and definitions, pictures, the labels itself, which I mentioned earlier, and the line in order to allow such protection is that there has to be some sufficient original creative work that would merit copyright protection. And also we have to consider another element, that even if the specific term of definition, for example, does not include some creative work by itself, however, the way that they're organized on the pages of the standards, this is protected as copyright by itself. So this is a very important distinction that we have to make, because sometimes there is some confusion there, and for that purpose, in fact, in CEN and CENELEC, we have a specific process whereby we allow, and I will describe it a bit later, we allow individuals to use graphs, tables, some small parts of the publications for non-commercial purposes that is needed. However, we need to keep in mind that all this content of the standard is protected as copyright under the law. So, and specifically, we have this context of fair practice within CEN and CENELEC, and it is described also in Guide 8. So what it means is that whenever a third party sends a request to reproduce a small extract of a publication, of a standard, for non-commercial, educational, or informational purposes, then the relevant technical committee is consulted by SENA-SENLEC, so the SENA-SENLEC Management Center, which it does, in order to verify if the technical committee agrees, if there is an objection, or there is something else we need to raise. And then in these cases, these requests are granted. So what this means in practice, imagine, for example, that there is a publication on a specific domain, and someone, could be a student, could be any individual around the world, and it happens quite often actually, they would like to use that small extract in order to publish a book about this specific standard. So they would like, for example, to use a very small extract of the standard in order to be able to publish in their book for non-commercial purpose. In these cases, these requests usually are granted. And the reason for that is because it's not a commercial, but rather it's an educational or informational publication. And then, as I mentioned, always in these cases, the technical committee is consulted to ensure that the request is relevant, is not too expansive, and also fits with the purpose of the publication itself, does not harm basically the content of the publication by itself. So another issue which is very important, and we would like to raise your attention to, is how to use the content of the copyright of other organizations within the SENA-SENLEC publication. So something that we have to bear in mind is that this is very important. The copyright of publications and the ability of SENA-SENLEC and the members to establish the copyright on these publications is fundamental in order to allow their adoption and distribution around Europe and the world whenever that is relevant. Now, in the cases where SENA-SENLEC have cooperation with various organizations, so that reflects to, for example, liaison organizations, other partners that SENA-SENLEC have cooperation with, or other like European associations, for example. In these cases, the cooperation agreement that SENA-SENLEC has with these organizations establishes some specific rules under which it is specifically stated that the representatives of these organizations, whenever they contribute some original work to the SENA-SENLEC publications, to the standards, then the exploitation rights of this remain with SEN and SENLEC. And this is important, as I mentioned, because there needs to be some chain of transfer of the relevant exploitation rights in that context. So that is one step. Whenever there is such partnership, the agreement of partnership specifies that the contributions to the work, the exploitation stays with SENLEC and the members. Now, the issue is that sometimes experts participating on behalf of other organizations, for example, through the national delegation principle. So these organizations don't have directly cooperation or an agreement with SENA-SENLEC, but possibly they have with the members. So in these cases, the members potentially have established such terms in the relevant agreements. However, if this has not happened, again, the experts are required at the beginning of the meeting to sign the exploitation rights statement, under which they agree to transfer the exploitation rights to SENA-SENLEC. And then this statement clearly states that the experts must ensure that they are aware and they acknowledge that they are the relevant copyright owners, or that they have the right to transfer these rights. If that is not the case, the experts then need to be aware, and they need to inform the relevant technical committee. In those cases, the technical committee and the secretaries will provide to them a specific form, which is called the Exploitation Rights License Agreement, ERLA. And under this agreement, usually this refers to the cases where there is a content to be contributed in the standard, which is above around 5% of the entire content of the standard. In these cases, the respective organization, is requested to sign this and agree to transfer the exploitation rights to SENA-SENLEC for this specific purpose. So it is important then that the experts must ensure that at all times they have the rights to contribute the content in the SENA-SENLEC deliverables, either because their organization has agreed to that already, or in the cases where this has not happened, then they need to go to their organizations and make sure that there's an exploitation rights transfer through this exploitation rights license agreement. So the ERLA, which I mentioned right now. So going forward, so what is the role of CCMC in that process? So CCMC, which is a Standardization Management Center, ensures that there is an enforcement of the Standardization copyrights worldwide. We coordinate with our members, national committees, and other national standardization bodies for the correct implementation of the Standardization commercial policy, and we ensure that there is a recognition of the Standardization intellectual property among stakeholders by promoting the sustainability and good practices of the system. So essentially, here at the Standardization Management Center, we ensure that there is coordination, there is also enforcement of the IPR, and we raise the relevant issues whenever that comes to our attention. And part of that is also offering these trainings, as we're doing today, to inform experts, stakeholders, technical body officers, and members how the system is progressing and if there are any updates as well on the relevant policies. Now, before going to the patents, I would like to ask, maybe I'll go through the questions that you have raised already. So what do you mean by moral rights? Joe, we addressed it a bit earlier. I hope that was satisfactory. If not, please, you can restate it again. Second question, does the moral rights mean that the contributing experts have the right to have their names included in the standard? Thank you. So it doesn't mean that. It means that they are able to use their individual contributions if it is identifiable to their person. So if it is possible to identify that this expert contributed this part of the standard, then they're able to use it for their own purposes as far as this does not inhibit the exploitation of the standard itself. It doesn't mean that they need to, and it's required to put their names on the standard itself. And the reason for that is, practically speaking, because the standard serves another purpose. So including the names of the experts would not really serve the purpose of the standard itself, but also is not required as such. So no, it doesn't mean that their names have to be included, but they can still use under the limitations that we mentioned earlier. Now, another question is, what about the right of translation of the standard on state native language? So under under the policy, the Standardization Guide 10, after the experts transfer the exploitation rights to Standardization, then Standardization transfer in turn the exploitation rights of the entire standard to their members. So under these exploitation rights statements and transfer, the members have the right to translate the content of the publications in their national languages. So normally this content is considered to be derivative work to the original content, which was the English, French, and German. So let's imagine that there is a translation in Spanish, for example. This translation in Spanish is related and it is derived from the original work, which was the English, French, and German standard. So, however, Standardization transferred this right to the members, and the members have the complete freedom to translate, exploit, copy paste, or use it as they wish. So the members then, in that case, have the ability to use it in their national context as they deem necessary. Yeah? The only restriction which is implemented under Guide 10, which is a basic principle for the European and the international standardization system, so Standardization, but also ISO and IC, is that the publications shall not be made available free of charge in the national territory. So that's the only restriction which is considered in that context. Now, next question: what about when using a part of a patent in a project text? That's a particular question. We will go later on the patents, but if I understand correctly, what you mean is copy paste the text of a patent description in a project text. That we haven't encountered that yet, by the way. But of course, the patent description itself is protected as could be protected as copyrights. I do not know if the owner would have any any reason why they would be interested to enforce such a copyright on the patent description itself. Usually the interest of the patent owners is to the use of the patent itself. So not the way that it has been described in the patent application or the patent registration, but rather the content of the patent itself. In that case, there are different rights which apply, which is the patent rights that we will describe later. However, in any case, we would recommend that even if that happens, you need to ensure that you have requested the relevant IPR owner to grant the rights for the use of such description. And then we will describe a bit later what are the implications in case there is a description of a specific patent, for example, or a specific patent technology within the standard. Now, are there any issues in contributing the same content to multiple standards? No, there is no issue with that. As far as the experts signed the exploitation rights statement at the beginning of the meeting, then this content can be contributed across relevant standards. And then I assume that you refer to the Standardization standards. So in our case, that is fine. And then, as I mentioned, this is an exclusive transfer of exploitation rights. Meaning that you cannot contribute the same content to another standards organization apart from Standardization, since this could create possibly a conflict there. So this is something that you have to also pay attention to. Although, of course, we have to bear in mind that, for example, Standardization, ISO and IC, they do cooperate in that context. However, the Standardization publications are different than the ones from ISO and IC. Now, I see another question. If the private company translates standards on national state language and give this translated standard to the NSB and the technical committee adopted this standard, this translation, are those company owner of translation of the standard, and can they use this translation? I cannot see the entire. Okay. Without asking NSB. No, so the question basically is if a member of Standardization, they request another organization to do the translation, and then the question is basically if this organization maintains the copyright to the translation, or and then if they can use it without asking the NSB. And the answer is no. So Standardization give the rights only to their members, not to other organizations. Of course, the members have the right to enter into contracts with other organizations in order to allow the translation of the work. However, it is expected that the content of the translation, so the translation itself, will be the copyright of the Standardization members, and this is stated also in Guide 10. So this, of course, it remains to the members to conclude such specific agreements with their counterparts. But however, in no case would such organization be able to translate without having the necessary rights for that specific translation. And of course, as I mentioned, these translations usually happen as a work, as a project, and it doesn't mean that they keep the IPR for that. Rather, they're just expected to complete a specific work for which the members normally should keep the IPR. Okay. So unless there are any other questions, we will move on to the patents part. Okay. So moving on then to the patents. Patents is another particular domain which has attracted quite an interest from IPR owners, so companies which own small or large portfolios of patents. They have attracted the interest of licensees. So usually standard users and patent users, which wish to implement these patents, but also they have attracted particular interest from the regulators across the world. So European regulators, European Commission, the courts as well. And there is quite an interest and discussion at this moment at political level with regard to this issue, and I will explain a bit later how this works. So first of all, we will try to understand a bit how the patents relate to the standards. What do we call essential patents? Some licensing conditions which relate to the standard essential patents, and the various interests and potentially the conflict of the interest between the patent holder, so the IPR owner, and versus the standard user in that case, or even the regulator. So the patent is different than the copyrights. So the copyright is something which needs to be creative, so some original work under which the law grants some exclusive rights. The barrier for the patents is even higher, and the reason for that is because the patents, when granted, they have the ability to exclude everyone from their use if the owner requests, if the owner wishes to do that. So anyone who wishes to use them, they need to have a specific license from the patent owner. So the patent is a set of exclusive rights granted by a national authority to an inventor. So it has to be an inventor for a limited period of time, usually it's around 20 years, in exchange for a public disclosure of an invention. So again, here, what we have is some creative work, which is an invention in this case. So not simply an original work of the mind, has to be an invention. I will describe a bit later what are the criteria for that, to which the law grants protection, exclusive rights for 20 years, usually. These exclusive rights include the possibility and the right of the owner to exclude everyone from their use during that specific period, and in exchange, the law offers this protection in order to allow the public to be able to use this invention. So let's understand a bit how the patent works. So a patent invention has to be novel. So it means that it has to be comprised not out of the state of the art, but it has to be something which was not there as a scientific or other creation itself. So it has to be something totally new and novel with that regard. Also, it has to be inventive. It means it has to be something which is ingenious as a device or a process, something which adds an additional layer of creativity compared to what already exists. And the third element that we need to consider is that the patent has to be subject to a possible industrial application. It means that there needs to be a possibility to implement such patent in a specific area or domain for industrial application. So it's not as in the case of a copyright, for example, which is a creation of the mind, which could be anything. Rather, the patent itself needs to be able to be implemented as a solution to solve a specific problem. So the bar then for the case of the patents is much higher compared to the copyrights. And now we will try to understand a bit why patents are important. So usually the patents are used by the relevant IPR owners as an ability to position themselves as organizations or individuals towards the commercial exploitation of their products. So imagine, for example, the laundry machine we mentioned earlier. By having a patent, the owner in that laundry machine is able to forbid anyone to use that specific technology. And if anyone wishes, they will only be able to do it if they take a license from the IPR owner. So it means that sometimes the IPR owners use the patents in order to position themselves in the market in a specific way and exclude others from using the specific technology for that specific period. So 20 years, for example. Another aspect is technology positioning. So the organization wants to position itself in the technological domain. Market strategy, which I mentioned earlier as well, and also to secure their business. So essentially, depending on the market portfolio and the combinations of patents that companies have, they are able to use this patent portfolio as a strategy to secure their business, position themselves in the market, and be able to sell more of their products and increase profit as well. This is usually the main target. Now, the issue is that we see there are more trends for the use of patents in relation to standards, particularly in the research domain, in the ICT domain as well. Telecom, it's quite an area where patents have been in a spot as well. We see that now with the Internet of Things, it is expected that patents will, and the appearance of the patents will become more pervasive in all areas of standardization as well. So before we had mainly ICT telecommunications, however, now ICT is going in all kind of traditional standardization domains. So there is an expectation and a possibility that there will be more patent density in this domain. So we have also device-to-device communications. So interoperability also is an important element with that as well. So based on a research which was done by McKinsey, it was identified that the IoT systems and interoperability could deliver around $4 trillion out of 11 trillion. So basically, the role of standards in the form of interoperability could have a huge impact in the potential growth of the market with regard to IoT systems. So what this means is that it is logically expected that there might be some increase in patent density with regard to all domains affected by IoT, for example, this interoperability with that regard. And for that reason, it is important that as a system, SEN and SENELEC are prepared to address this, and we have, in fact, a system in place which addresses specific issues with that regard. So we will go a bit more in detail on the SEN and SENELEC policy, but first of all, let's understand what is an essential patent. So as I mentioned, usually you have experts participating in the technical committees. Sometimes these experts, they come from organizations which could be owners of patents. So when they contribute to the standard content, it is possible that they may refer to technologies which are protected under patents. So it is possible then that the final content of the standard may include references to technologies which are patent protected. So essentially what it means is that if a standard user wishes to implement this standard, then inevitably they will have to also use the content of this patent in order to be able to implement the standard itself. So in this case then, when it is not possible, according to the patent holder at the time of the standardization making process, to make a product or method according to the standard without infringing the patent holder's right on that patent, then in this case, such patent is considered as essential for the standard. So important here that the declaration of the essentiality is based on the belief of the patent holder at the time of the standardization process. So it is not something which is declared by SEN and SENELEC or by the organization themselves or their members, but rather essentiality is something which is considered and declared by the patent owner themselves, or sometimes by other experts participating in technical committees. For example, it could be an expert, and due to their knowledge of the relevant technologies, they're aware that another organization, which is maybe not participating at the technical committee, their technology is being referred to in the content of the standard. Then, in these cases, under the SEN and SENELEC policy, which is described in the SEN and SENELEC Guide 8, the experts are invited to inform the technical committee if they're aware of any patented technology which is may be referred to in the standard content. And this is very important because the standard users need to be aware whenever they will implement a standard whether there are any patents which are relevant for this specific standard. And this is the purpose of having a declaration. So in the Standard Guide 8, specifically, it is requested that, those patent holders need to declare their patents and also need to inform SEN and SENELEC under what conditions, and the standard users, of course, through that process, if under what conditions they wish to license such patent or they don't wish to license such patent. And then we'll examine a bit later how that works specifically. So as I mentioned, a specific and important element in the standard development process is that any expert who is aware of a patent which could be relevant for the content of the standard is requested, is invited to declare this patent technology. And then the relevant patent holder will be invited to fill in the declaration form under which she or he is requested to declare under which conditions she or he is willing to license the relevant patent or patents. Now, I will describe a bit here how the declaration looks like. And this is in annex to Guide 8. So I'll give you a bit of time. Here you see the first, so at the first part of the declaration, and then as you see, there are three options there. The first part of the declaration allows the patent owner to declare, and by ticking the box, to declare if they wish to license the patent under no like licensing conditions, so free of charge. There is possibility under this specific declaration. Second option, which the patent holders have, is to license their patent or patents under fair, reasonable, and non-discriminatory terms, so FRAND terms. This is very important. And why it is important is because it is possible that the patent holder wishes not to license the patent. So they could say, I don't wish to license the patent. However, the second part is important because under the relevant court decisions which have appeared across the world, either in the US or Europe or Japan, for example, or Korea, in the cases where a patent has been declared and is relevant to a standard, then in those cases, the patent holder needs to license not under any conditions, but these conditions have to be FRAND, so fair, reasonable, or non discriminatory, or they can choose to license it free of charge. Now, in the cases where the patent holder does not wish to license the standard, it is important in these cases that this is known to the relevant SEN and SENELEC technical committee, because, and this is why we request that such a declaration takes place as soon as possible. The reason being that if such an owner and holder declares that they don't wish to license, in those cases, the technical committee is able to identify a design around that specific technology. What it means, for example, is that if the patent holder says, no, you know what, I don't want to license my patent for the use of the standard, please exclude me from the process. In those cases, the technical committee will identify a way to find another solution in the description of the relevant solution in the standard, so circumventing and not including the relevant patent technology. And that's why an important element in the under Guide 8 and the principle which is included there is that patent declarations have to take place as early as possible in order to allow the relevant technical work to proceed as smoothly as possible. And after this declaration takes place, and depending on the various conditions, of course, if it is free of charge or under FRAND, then after publication of the standard, a list of the relevant patent declarations is provided on the SEN and SENELEC website. So in this way, and also there is a mention at the beginning of the standard if there has been a patent which has been identified for this specific standard, and there is a mention of the relevant patents with that regard. And as I mentioned, the reason for that is in order to allow disclosure and public knowledge to the standard users for that purpose. So let's examine an implication. For example, imagine company A makes a product and needs to implement a standard. The standard contains an essential patent technology of company B. Company A needs a license to use that patent technology. So thanks to the patent declaration, company B and any successor is committed to deliver the license for free or by payment at FRAND conditions. Now, there is a question very often, what exactly does FRAND mean? I mean, it's quite general in terms. And that is an important question. There's a lot of discussion which has come up at legal and political circles on that. There is a political discussion at the moment. So also the court of the European Court of Justice, the recent case, declared that that it's not possible to define exactly the content. However, there are some criteria and the process that needs to be taken into account on how to establish that it is a FRAND, under FRAND conditions. So basically, the determination of if a license is FRAND depends on the specific cases and will be determined on the specific cases. And then this is not something which is determined by CEN and like other members, but rather it is something which is determined by the patent holder and the licensee in that case, so the user of that specific patent. So this is a process which takes place outside the standard development itself. As mentioned, both parties need to negotiate the terms of the license. So what CEN and the members ensure with this regard is that there is a disclosure at the earliest possible stage of the relevant essential patents, and then this will allow the standard users to be able to be aware that there are patents which could be essential, and to be able to address the specific licensing request to the patent holders. Now, it will be interesting also to see how the whole system works, because there are different parties which are involved with that regard. So let's imagine that we start from the bottom there on the left corner. You have various products in the market. CEN and CERNLEC develop the relevant standardization standards for those specific products. At the same time, these need to comply with specific regulations and legislation. The European Commission is quite interested on the relevant patents which could be used for the implementation of these standards. Specifically, this refers to EU competition law principles, because one of the main considerations of the European regulator, so the European Commission in this case, is if such standard essential patent holders, so SEP holders, are actually using these patents in a way which is compliant with competition law, or if they are using it in a way which is in breach to the relevant EU competition law principles. So the patent office is involved also in that, considering that there are many patents concerned. There's a description of the relevant patents. Sometimes it's not clear at what stage the patent is. It could be at the stage of the application, or it could have been granted. And there always, there's always a consideration of if there are disputes, legal disputes with regard to the content of the standard. We have seen very often that there are legal disputes between companies with regards to patent infringements. What is the scope of the patent? So all these discussions essentially affect the implementation of the standard itself. So the standard implementers are and need to be aware of the relevant discussions, and of course their consideration is that things need to be kept as much simple as possible for them. And an important element for that is to have the information necessary of the relevant discussions and the progress of the negotiations. So inherently, we see that there is a tension between the various interests with regards to the patents. So essentially, you have, in the context of the patent of the standard development process, you have interests of the patent holders, but you also have the interests of the patent users, which happen to also to be standard users at the same time. Now, because we expect, as I mentioned earlier, to have a patent density in the standard, so it's possible due to the shifting of the economy towards more digitalized content that there could be more patents relevant to the standards that SENA, SENLEC, and the members will produce. So this is an important consideration that we have to take into account. Okay. So there is certainly a tension and various considerations there. Now, from the side of SENA, SENLEC as standards bodies and their members, it is important to ensure that there is a balancing of these rights to the extent possible. In the view of standardizers, it is important to ensure that the best content is contributed in the standards, so the state-of-the-art technology is included, and then of course that the implementers of the standards are able to actually implement them in an easy fashion, so there are no barriers to the implementation of the standard. That's why we have the policy under Guide 8, which provides a framework for the relevant disclosures and circulation of information as much as possible, and to ensure that there is also some ground rules of how that works. Now, because there has been quite some discussion in the past on this domain, SEN and SENLEC have been quite active in this area. There was a position paper which was circulated in 2015. This was in response to the European Commission's public consultation on patents and standards. This position paper was also supported by ISO and IEC. Considering that also ISO and IEC, they're very close to SEN and SENLEC with regard to the relevant policies. Now, again, in 2016, SEN and SENLEC also issued a position paper, and I would advise you have a look on those. They're available on our website, in the SEN and SENLEC website. So there was a second position paper with regard to the content of the FRAND terms, and that was in response to the relevant discussions, policy discussions, but also European Court of Justice decisions on the process of determination of FRAND. So an essential element which I mentioned earlier in the policy is that it is requested from anyone who is participating in standard development work to declare as early as possible if they're aware of any patent which could be relevant for the implementation of the standard. In fact, the chairs of the technical committees and working groups and conveners of the working groups are invited at the beginning of the meeting to request if anyone is aware of that, and they record also in the relevant minutes any responses. So if anyone says, oh yes, I'm aware about the existence of a patent, then this is recorded as well, and then so that there is an appropriate follow-up with the relevant patent holder. Now, SEN and SENLEC themselves do not determine if a patent is essential for the standard. This is something which is left to the relevant patent owner. So a patent owner may consider that this is relevant and this could be essential. So it is based on their opinion. The reason being for that is that SEN and SENLEC are standards bodies. So the aspect of the patents, it's something which is different and is left between the relevant patent holder and the licensees, so the patent users / standard users, to consider the relevant licensing considerations. So SEN and SENLEC do not engage in licensing negotiations with the relevant parties. This is left between the parties concerned to determine themselves. Also, SEN and SENLEC do not resolve disputes with regard to the licensing of standards and patents. There are other bodies which are more competent to determine such aspects. For example, courts, relevant courts, or could be arbitration or mediation processes, exactly because this is more relevant for them, and they have the knowledge to be able to address such considerations. Now, I think maybe we can address some questions on the issue of patents because we're almost there. So I see a question: what does it mean to disclose applicable patents at the earliest possible time? I'm aware of a project where a patent holder does not want to disclose before the CDV stage, thus trying to prevent the standardization committee from working around the patent. How should the committee treat this situation? So, as I mentioned, the determination of if a patent is essential is left to the patent holder itself. So it's not something that Standardization can determine by itself. Now, there are, of course, possible solutions with that regard. So if, for example, there is an expert which considers that actually the patent is essential for that specific technology, usually the way we work on that is that we try to have a discussion with the relevant parties and then try to resolve the situation in a way which addresses the concerns of all the parties concerned. Imagine, for example, it is possible that a patent holder does not wish that her or his patent is referred to in a specific standard. So in that case, if the technical committee believes that actually there is an issue of essentiality in that with that regard, a question rather of essentiality, without even determining the essentiality aspect, then the technical committee could by itself decide to use another technology. So it doesn't have to wait until we go to the stage of the formal vote or the completion of the standard. So if there is an issue about the essentiality of the patent, then experts are invited to raise this during the technical committee meetings, and the technical committee, of course, will need to address the specific issue at the earliest stage possible. So it is a very positive thing, in fact, that experts raise these questions also in this specific technical committee. And then I would expect that the technical committee takes the initiative to address the question and maybe take another technology. So use another specific technology which could be relevant for that. At the same time, it is good that there is a communication with the relevant patent holder. So I understand from this case that the patent holder is known. So it would be a positive thing to invite the patent holder to have a discussion with her or him in order to determine why maybe they wish or they do not wish to declare the patent. Because an important element is that we would like to avoid that there is in fact a patent which could be essential, and then later someone could claim that oh, actually yes, this is essential and I want a licensing, which however is not already declared to be under front terms or free of charge, because in this case the courts would determine likely that there is possibility to have a patent ambush, which is not certainly something we would like to see with that regard. Of course, the reason being that this would complicate the implementation of the standard, but also it would likely result in legal disputes between the relevant patent holder and the licensees, the users, rather. So the best way to address these cases is at the earliest possible occasion, declare the patent. The patent holder can decide under what conditions they wish to license it or not. If they don't want to license it, that's fine. The technical committee will try to find another way to address a specific issue. However, in any case, it's positive for all the parties to have some communication, address these issues. And I would advise also, if this issue is still persisting, please contact the secretary of the technical committee, also my colleague in the CCMC, but also me. I will be very happy to discuss this with you and find ways to address this specific occasion. Okay, it's a pleasure. So I will summarize a bit now what we discussed, and then we will maybe open the floor if you have any more questions with that. So as key learning points from today, we have to bear in mind that the digital transformation will likely result in increased patent density in standards. This is something which we receive messages about. This is something we're trying to discuss as well with the European Commission. So bear in mind also that the European Commission last November issued a communication on standard essential patents, under which they requested from the European Standardization Organizations, but other SDOs also, to take some steps to address the relevant concerns of the European Commission. In the case of Senaselec, essentially our policy addresses these relevant aspects. However, there are some discussions with the European Commission, for example, to make the database even more user-friendly with that regard. The issue, of course, is that in the case of Senelec, we have few patent declarations. The reason being that most patent declarations take place at the international level, so ISO and IC. So you will see ISO and IC, they have much more patent declarations compared to Senelec. Also, ETSI, telecoms, they have thousands of patent declarations. The reason is exactly because telecom is an area where primarily patents have arisen, and then you see that there's some important policy considerations there, considering that the telecom area is quite regulated. However, we expect that in the next period, as there is a transition towards a digital economy, there might be more patents arising with that regard. As I mentioned, it is important that any patent which could likely be essential to be declared as early as possible, and the license declaration to be received from the patent holders. With this regard, we understand that maybe sometimes there are concerns, there are issues, there are discussions. However, the earliest that they are addressed, the better it is for the patent content, for the experts, because the experts also wish to ensure that the standard is published in a way which is possible to implement in the market without any issues, legal issues arising at a later stage. So the earlier that is being addressed, the better it is for all the parties concerned and also for the standard users. So primary concern of the patent policy, as I mentioned, is to ensure that there is a balancing of the various interests. So Senelec and the members wish to ensure that all the parties are brought together in the standard development context, any considerations are being addressed, and the best technologies are being referred to as a state of the art in the standard on a consensus basis. Now, with regard to the copyright aspect, it is important to make sure that the experts sign the assignment of rights statement at every meeting. We know that maybe this is quite the administrative purpose sometimes, but in practice, how it works is that at the attendance sheet, usually there is attached also the assignment of rights statement, which the experts are invited to sign. So this is done in a very simple and easy way, but it has to be ensured that the secretaries and the technical body officers ensure that the experts sign this statement. Now, whenever there is a request for fair practice, so whenever someone wants to use the content of the standard, like a table, a small extract, for non-commercial purposes, so educational, informational purposes, this is possible, it is allowed. They just need to send to us, to CCMC, the request, and then they will need to fill in a form which will allow us to process the request. And then in case there are bigger issues which require further clarification, in those cases, CCMC, so the Senelec Management Center, and JCAC, the Joint Commercial Advisory Group, do provide guidance and clarifications under the principles of guide